Hey friends, welcome back. Today's update is the result of one of those chaotic days where everything flips mid-recording. I had already spent time filming, editing, and finalizing my video when suddenly a new court order dropped and everything had to be scrapped. But that's how it goes sometimes, especially in ongoing legal battles. So let's dive into the latest development in Blake Lively's lawsuit, particularly focusing on the judge's new ruling concerning her emotional distress claims. This ruling is a significant moment in the case, and it really exposes some of the behind-the-scenes friction and strategic maneuvering between both parties. Initially, it was revealed that Lively was attempting to withdraw her emotional distress claims, both the intentional infliction of emotional distress, RARC's IED, and the negligent infliction of emotional distress, ORED. At the heart of this issue was a disagreement between her legal team and Wayfair's lawyers about how these claims would be dismissed, specifically whether the dismissal would be with prejudice or without prejudice. That detail might seem minor, but it's actually hugely important. A dismissal with prejudice means the claims are permanently gone. She cannot bring them back to court. A dismissal without prejudice means she could potentially refile them later. So Wayfair understandably wanted clarity and finality. They didn't want to go through costly discovery only to have these claims boomerang back after the fact. Wayfair had filed a motion to compel Lively to produce medical documentation to substantiate her emotional distress claims. For a claim of IIED or NIED, it's not enough to say you were emotionally harmed. You need medical proof. That means disclosing records, names of providers, therapy notes, or anything else that shows real diagnosable emotional trauma. However, shortly after Wayfair filed their motion, Lively's team turned around and said she was going to drop those claims. That's where the confusion and controversy began. Wayfair, trying to protect their legal strategy and avoid future headaches, said they would agree to the dismissal, but only with prejudice. Lively's team wanted the claims dismissed without prejudice, so they could theoretically bring them back later if they wanted. Her lawyers then filed a letter with the court, arguing that Wayfair's motion to compel was now moot since the claims were being withdrawn. They accused Wayfair of using the court system for media attention, suggesting that the whole thing was just a public stunt to discredit Blake. They even asked the judge to sanction Wayfair for filing what they called a frivolous and abusive motion. Now in federal court, if all parties agree to dismiss claims, it's called a stipulated dismissal. That requires every party involved to sign off. Wayfair and Lively both have to agree on the terms. But here's where the judge, Judge Lemon, stepped in with a no-nonsense ruling. He denied the motion to compel, not because he found Wayfair at fault, but because Lively had already told the court she was dropping the claims. But that's not the full story. The judge also made it clear that there was no actual agreement between the parties yet. Lively had prematurely told the court that a stipulation had been reached, when in fact it had not. Judge Lehman clarified that unless both sides come to a formal agreement, stipulated and signed, Lively must file her own motion to dismiss the claims. Only then can Wayfair respond and argue their position on whether it should be with or without prejudice. The judge also laid out a warning. If she does nothing, if she doesn't file a motion or finalize an agreement with Wayfair, then she will be barred from presenting any evidence of emotional distress in this case. Full stop. That's a serious blow to her side. The judge is signaling that he won't let her play both sides. She can't refuse to provide discovery, walk away from the claims to avoid scrutiny, and then try to bring them back later when it's convenient. To be clear, the judge didn't rebuke Wayfair or punish them for filing the motion. In fact, he didn't even entertain the accusations made by Lively's team about media abuse or harassment. He simply denied the motion based on her own assertion that she planned to withdraw the claims. But critically, he did not order the dismissal of the claims himself because the parties had not finalized any agreement. This means Lively misrepresented the situation to the court. That's not a good look. The judge appears to be catching on to some of the games being played. He reminded Lively that unless both sides agree, the process can't move forward. The concern raised by Wayfair is valid. They don't want to be blindsided later with refiled claims after the discovery period is closed. Discovery is a critical phase in litigation where both parties exchange evidence. It's time-consuming, expensive, and strategic. Wayfair doesn't want Lively sitting on emotional distress claims and avoiding producing her records, only to suddenly revive those claims when they can no longer investigate or defend against them. So now Lively has two options. She can either work out a stipulated agreement with Wayfair, agreeing on whether the dismissal is with or without prejudice, or she can file her own motion to dismiss the claims. If she files a motion, Wayfair can formally object and make their case to the judge about why the dismissal should be with prejudice. But if she chooses to do nothing, she will lose the ability to submit any evidence of emotional distress at all, even in relation to other claims that are still part of the case. This puts Blake's legal team in a tight spot. Her attorneys had been arguing that even if the specific IIED and NIED claims were withdrawn, she could still introduce emotional distress evidence as part of her other claims. The judge is now making it crystal clear, no, if she doesn't handle the dismissal properly, no emotional distress evidence of any kind will be allowed. That's a massive limitation, especially in a case that may involve allegations of workplace misconduct or harassment. In such cases, proving damages often hinges on showing emotional or psychological impact. Without that, it's hard to argue for significant compensation. So in essence, the judge is telling Lively, stop playing games, follow the rules, and cooperate with the opposing side, or you will lose the right to argue a huge portion of your case. He didn't strike Wayfair's motion from the docket as abusive. He didn't sanction them. He just made it clear that he's taking her own words at face value, that she wants to drop the claims. And if that's the case, then she needs to do it correctly. Otherwise, the consequence is that her emotional distress narrative is off the table entirely. This ruling is firm but fair. It isn't biased. If anything, it shows that the judge is becoming increasingly impatient with the back and forth tactics from Lively's team. He's clearly not impressed by attempts to drag him into every disagreement. Judges aren't babysitters, and they don't like being forced to referee every minor fight. Courts expect attorneys, even those on opposite sides, to resolve things like discovery issues amongst themselves. Lively's team is bringing every squabble to the judge, expecting him to discipline the other side. That's not how litigation works. In the same vein, Wayfair's legal team has also responded to Lively's motion for sanctions. She had filed that motion asking the court to punish Wayfair for filing what she called a frivolous motion to compel. Wayfair's attorneys hit back, pointing out that her motion misused Rule 11 of the Federal Rules of Civil Procedure. Rule 11 is designed to punish attorneys who file documents in bad faith or for improper purposes. but it's not meant to be a shortcut for winning arguments or avoiding tough rulings. Wayfair argued that Lively's motion for sanctions was itself improper and baseless. They noted that she was using the motion to relitigate her earlier attempts to get the case dismissed. She had already made her arguments in a different context, and now she was just rehashing them under the guise of a sanctions motion. That's not how the rule works. Wayfair emphasized that they had even provided her attorneys with case law and a full explanation of Rule 11's scope, which she ignored. They also pointed out that Lively was trying to get the court to punish them for statements made outside of the courtroom, specifically media statements. Rule 11 does not cover what lawyers say to the press. Yet, ironically, her attorneys had made their own media statements against Dustin Baldoni, Wayfair's legal counsel. You can't cry foul about press comments while making your own inflammatory statements to the public.